Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, March 11th, 2025 at 9:04 in the morning, and we've returned from a lovely week off. I hope everyone had time to recharge because it's going to be a rough 3 weeks, I think. So we're going to start this morning, going through H243. And I think if you remember, we had David Hall from the Secretary of State's office, kind of give us an overview of what would be in H243. And again, it's an act relating to the regulation of business organizations. So David, you'd like to pull that up, and welcome this morning. Thank you for coming in.
Sure. Great. For your record, David Hall, not Legislative Counsel, reflexive, Director of the Business Services Division at the Secretary of State's office. This is on H243. And so I wanted to defer to you, Mr. Chair and committee, on whether you want to try to look at bill language, or do you want to continue using the color-coded table and talk about the subjects. Last time we went through an overview of organizations, of what my office does. We looked at the purple provisions together concerning harmonization of the agent of service of process, and we talked about that in some detail. And then I have the other color codes that we can go through by subject matter, or we can look at a bill text. It's up to you.
I think we'll continue on with color codes and
Okay.
see if we can finish that up.
Okay. Again, you do have now H243. It started life as a short form, and you do now have a bill text. We're still working through the process of ironing out some bugs, but it's in pretty good shape, I think. Good morning. So just to give you the quick reminder, we're the Business Services Division. We're across the street. We are the place you go to form most business entities by filing documents. So you start life with us, you maintain life with us, you end life with us for those statutory entities that require some sort of filing to be in good standing, to form and remain in good standing. And that's why we do what we do. That's what we're talking about, are tweaks to the statutes that govern those different types of organizations and the processes that govern how we do our work. Just to give, it's been I don't know how long since we've seen each other, but just to give you an update, we are in the third and final month of this first quarter, which is primarily when most LLCs and a lot of corporations file annual reports. So far this year, my 6-person division, Neil Rose is with me again from the division, and our colleagues have processed over 44,000 records. We're still getting about 50 phone calls an hour and dozens of emails a day for assistance with registration, filings, all the things. So it's super intensive, but we're doing, I think, a pretty good job getting things through. We're still finding bugs, still fixing bugs, but it's all part of the plan. And the work that I'm proposing to you in the statutes is for the long range future, to try to make things easier for businesses, for us, for you. And that's really the spirit of what we're proposing here. So we'd already discussed the purple. We talked about agent for service of process. This is the individual resident or the authorized business who receives process if there is sort of written demand, a lawsuit. We talked about how we want to just try to harmonize the language around who can be an agent, because some statutes, allowed only certain kinds of entities for no good reason, or wasn't entirely clear about residency. It wasn't quite clear how we changed those. And we're trying to harmonize in the sense that a statement of change would be the document that you would use to update your agent information across the board. So we covered that. And if you have more questions to come back to agent, please raise them. But I'm going to move on now, in the interest of time, to the green. So this is the category here is harmonized initial filing and annual biennial report provisions. This is concerning principal information and contact information. And I'm glad to see my friends from the Bankers Association here. They were one of the groups, and I think I mentioned this last time, who told us we absolutely use principal information in our work when we need to identify people who are applying for financing, when we need to know who the owners are, when we need to know who's associated with these businesses. We come to your site, we check that principals are listed as they are applying. We also heard that same information from other regulatory agencies, from DFR, from labor, even from DEC and ANR, Department of Taxes. I want to remind you that the statutes, when you file a business, have a very narrow scope of information that you must supply in order to create the entity. It technically does not include owner or principal information in most cases. We have offered the opportunity to supply this information or collect it and make it public if people want to provide it. It is required in certain periodic reports subsequently. You have to identify your directors, officers with policymaking authority, for instance, in a corporation's annual filing. But that's a periodic update that happens for most entities on a yearly basis, but doesn't apply to all of them because not all of them have annual reports or biennial reports. And it doesn't necessarily mean you're going to get that information at the beginning unless they want to supply it. But as I said, a lot of people do, and a lot of people use it. So the thrust here is basically make it really easy for people and make sure they have a clear line of statutory authority to give us principal information if they want to provide it, and to update that information and contact information when they come back for the ARs or their BRs, their annual report, biennial report, just so that, if you're only going to touch down one time per year at our office and have your contact information, your principal information on the record, we want to make it easy for you to just keep it up to date as much as possible. So you'll see my bullets here. These changes specify a business can identify and provide contact information for optional principals in its initial filing, which conforms to current practice, but is only implicit in the law. I want to clarify that for entities that file an annual report or a biennial report, which is a nonprofit, they may update in that filing the business's purpose, email, address, or principal information. And a couple of notes here: a business cannot use an AR or BR to update its name, entity type, or other provisions, or its agent information if this bill passes. And this proposal does not add, delete, or modify the report requirements themselves. But we are suggesting that we take a look at that in the study work that is the last section of this bill. And there's a couple of reasons for that. There's some weird timing issues. For instance, for a corporation right now, the AR is due 2.5 months after the end of their fiscal year versus an LLC is 3 months. We've talked about, I think last time, that the nonprofits have a biennial reporting requirement, which means we may only get an update with their information every other year. And then we have other entities that have no requirements. So the question of what purpose do these reports play and who should report and when, I think is good to look at holistically, but I'm not going that far right now. Right now, I'm just trying to say, let's make sure that people can update their information when they file with us and make it easy, make it clear in law that they have that ability. So if you want to look at, this is really kind of hard to navigate when I can't. I'm going to stop for a second because I can't switch documents. And now it closed out of everything. I'm sorry. What I was doing there was going to go back to the table so you could actually look at some of the language that goes with the green sections. So let me pull that up. And for some reason, I'm listed in your witness list. two times, two ways. But I did find it. Here we go. All right, we're back. I'm going to share this. Okay. So I'm going to move through green here so you can see what the actual language looks like when we talk about this. So this is a good example here. We're in Title 11. Oh, and I updated this table and I wanted to call this for attention that you'll still have the same number in the parens as my original notation of the section. The section is the actual section of the bill as it's constituted. So we've gone from like 100 something sections to maybe 20, because you can, if you want to amend all of 11 VSA chapter 25, that could just be one section and you change it. But so I've got the actual section from your bill noted here, and then I've got the change as I had indicated it originally in parentheses. So you'll be able to track those. So this is a good example. We're talking here, we're in 11 VSA chapter 7, I believe, and we're talking about unincorporated nonprofit associations. And right now, when we form these, it's really old law. I'm not sure, frankly, the last time it was updated, and the modifications here, we already talked about the purple to mirror the process for others, for agent changes, but here the harmonization would be in the initial filing. We want everything to be business address. Right. We don't want to know where people's houses are. We don't want that to be part of the public record necessarily. We want a business address. And then this little language is not a major addition, but it just says you can add in your filing the principal information of anybody else you want to identify. Our system already has the ability for you to enter the name and the capacity of the person, whether it's a manager, a member, a director, and then there's an other that you can specify because, who knows? You can call your person whatever you want, but there's a few stock standard titles for capacity for the different entity types, and then there's the ability for a flexible entry under the other category. So same principle here, same type. Email, I don't know, that's HPs. This is any other information they provide. Now, there's a little bit more going on in this section 1621, and it looks gnarly, right? There's a lot of strikes and underlines, and it falls under the green umbrella because it is a harmonization of initial filings. But this is 11 VSA chapter 15, and this is the section of law that I talked to you last time that we mandate the registration of partnerships, which is not a typical practice uniformly in the world. I would say most jurisdictions do not mandate filing by partnerships. Remember, partnerships, we are our common law organization. When you and I go into a endeavor to make money, whether we meant to or not, we just made a partnership. And Vermont has this wonky thing where we have our old statute that governs partnership, and then we have the Uniform Partnership Act standard that governs partnership. This is one of the things I suggest we look at together over the summer. But in the meantime, my suggestions here in 1621 are to try to standardize the initial filings and the amendment filings for partnerships. As long as we're going to have these registrations, let's just make them work the way the other ones do, which means there's an initial filing that tells us certain information, one piece of which is identifying the partners, blah, blah, blah. And then there's the agent information, there's address information. We have amendments if we need to be able to update this information. That's just how the rest of the things work. This also applies to two other types of registration. These are also a little bit unique. And I mentioned this last time. The second kind is the unincorporated nonprofit association, UNA for short. And I mentioned this is like your neighborhood, maybe it's like a neighborhood association, or it's a parents group that wants to raise money for a soccer club. This is the nonprofit version of a partnership, basically. You're undertaking some activity as a group, as an association of individuals who do not have a profit purpose, but you're something, right? There is model UNA legislation that has been proposed to this body in the past. It never was taken up. That would set sort of like the ground rules for how these things should operate. We don't have that, so we don't really have much more than you have to register it and tell us who the individuals are in that association. So that's what's going on here. That's sort of the second group that's governed under this section of law, and it's the same principle. We require you to register, so why don't we do this in a uniform way? Tell us who the people are, tell us business addresses, tell us the purpose. We can look at all the words, but that's the same thing, basically. The third piece here, oh, please.
Clarifying on
Yeah,
that.
sure.
So currently we are requiring these nonprofits to register, but just doing it in a different way. And now we're standardizing that.
Yes, the thing, that's a great way to phrase it. That's exactly right. And we are not changing right now in this bill the 5-year cycle that these types of entities are on. Remember, most of the other ones are on a 1-year renewal, like the LLC, the corporation, or the nonprofits on a 2-year. These are 5-year registration, and there's no proposal to change that. It's just the substance of what information you would give us when you organize the thing. And it's to make it basically be the same process and the same information. The third piece here, and this is probably a place that after LLCs touches the majority of people's lives, is the assumed name. This is for individuals in this section. So this is a sole proprietor who wants to do business under a name that's not their own. You know, your name is Jim, but you're not doing business as Jim. You're doing as Handyman Services. You have not formed an entity. You're not an LLC. You're not a separate organization. You're still you, but you're doing business under a different name. Last time we talked about sort of this public information function and this consumer protection function of knowing who you're doing business with. And the way you do that is you look up the name. This is the name. Individuals can take on an assumed name. Businesses can also take on an assumed name, but those have to be filed with us. Also on the 5-year registration cycle, also proposing to have just the same information points about who you are, what your business address is, what's your purpose, et cetera, et cetera. But not changing the substance of that requirement for an assumed name to register and to be on that 5-year cycle and to tell us who you are, how we get in touch with you.
David, is there any requirements within that 5-year?
Mhm.
And if someone decides that they don't want to do business anymore, they stop.
It can stop. There's no requirement to terminate the name. There's a process for somebody to come in and say, this name is not being used. We would like you to decide that. And then if you find that they're not using the name, free it up. That's 1636. That's one of the administrative pieces we can talk about. You look like you.
Well, I'm just wondering if that's something that we should think about.
Yeah.
Maybe, for the summer. It just seems like a drawn out process to figure out if someone's using the name anymore or not.
Yep. Yeah.
Where it would be much simpler if they're required to notify you
Sure.
that they've stopped business and
Yep.
stopped doing business and the name is then freed up.
Sure. Yeah, it's not a requirement. And technically it I would say in the case of entities and organizations, like you're supposed to file a closure filing when you finish winding up and stop doing business. doesn't always happen. Doesn't happen a lot of the time. So that may be another reason there is this underlying process for people to be able to essentially say, you know, we don't think this is being utilized. We would like to use this. So, but I hear you. I think it's a good idea. I would give me a chance to look through here and see where that might fit, but we could very easily put in a requirement that says if you stop using a name, notify us. We'll cessate it.
Just a counterpoint to that, one concern I would have is if you require someone to do that, someone could technically keep a business name open forever. And, you know, if there's no fees or anything, then they could stop another company. Maybe there's some, you know, rivalry or something.
Sure.
And I would be concerned that's not for us.
Okay. I hear you. So you are required to register the name. It's good for 5 years, and then you have to re-register it. There are fees associated with both of those actions, so there's some skin in the game. And again, there is a process by which somebody could challenge whether the name is actually being used. But you know, could a person for some sort of anti-competitive purpose try to hold the name back? Sure. But so that's when it gets kind of thorny in 1636 administrative proceedings about whether they use the name or not. We've had probably 5 or 6 of those hearings since I've been in this position, most of them related to people actually taking a lapsed name and trying to capitalize on somebody else's failure to renew a name. Not in the other circumstance. I've not yet seen a circumstance where somebody said this name looks like it's dormant and nobody's using it. That could happen. The thing is, too, you have to keep this in mind, is this is a place where you register those names, and we are the filing office of record for where that happens for sure. But there is a separate body of law under the intellectual property framework that governs who has the right to use a name as far as the court is concerned. So we are not the arbiter of who has the better right. We are the place, we are the first stop, we are the point of registration and renewal. If you don't like our decision under 1636 concerning a name, it's a de novo appeal to the Washington Civil Court. And, there are separate issues involved in whether somebody had the first and better right to use the name, whether they're still using the name, whether it's protected as part of their intellectual property. So it gets complicated quickly, but on our side of things, yes. There's a tension between, a public facing place that says this person is using this name and has registered and reserved it versus businesses going out of business all the time. And we want a highest and best use of a name if it's a good name to use in Congress. So something to consider. So other that okay. It, that's annoying. I'm going to just touch on this here because we're in the same place and it's on the same conversation. It's yellow, it could be green. I think I flagged that last time, but this is the well, here you go. How about this, Mr. Chair? So 1628, the certificate of cessation of business or change of business status. It definitely goes to this point. I'm glad that we are going to get to this because I'd forgotten this. So right now, the partnership, the UNA, and the individual assumed name have these two filings. The certificate of cessation of business, which is a closure filing, and also the change of business status. So the former actually is doing what you had suggested, and I forgot that it also applies to assumed names. I was thinking partnerships, but I've rephrased it there. You'll see in subsection A. So a registrant that would apply to any of those types ceases to do business in the state shall submit to the Secretary of State for filing a certificate of cessation of business not later than 10 days after the date of cessation. I think that's probably what Neil was trying to tell me when I got off track. So that's good. That's there. That's when you stop. But the big change in my view for this one is allowing amendments for these entities. Right now for a partnership. We built a system and we try assiduously to follow the law. And sometimes that's for better and sometimes that's for worse. And this is one of the cases right now is for the worse, because right now you're not able to amend a partnership record necessarily. You can't add a partner. If you're an LLP, even you can't just come in and tell us like, oh, we've got some shifts. You have to cessate it and then re-register it. You can remove people, but you can't add them. There's not a clear line of statutory authority for us to be able to make amendments to these types of registrants that we have for all the others. And so the changes here would specifically allow for amendments to let these people, and if you think over a 5-year span, you want them to be updating their record. And so there's a clear line here to allow that. You see subsection B, if you add or remove an individual partner or member named in the registration, then you need to file an amendment with us within 30 days of the change. And C, this is the agent information, same principle. You're going to harmonize that through filing a statement of change pursuant to 1655. So that's most of the partnership UNA assumed name for individual pieces. I'll give you one more example here because this is the kind of change that we're proposing across the board for all the periodic filers and harmonizing principal information and contact information. So 11 VSA 3293. This is the LLP annual report provision. It's very similar to all the other ones. It's sort of got the same build to it. The change would be, you'll see on the screen here, the new subsection G. And this basically this same language is repeated or inserted for the other entity types as well. Said simply, the Secretary of State shall amend its records to reflect the change if specified in the report to the business's purpose, email, address, or principal information. That'll allow people to do the automatic filing, update all of that information if they want to in the AR or the BR, and we don't even have to review it at that point. I mean, frankly, we can't review all the ARs. Like I said, there's already been like 40,000 of them. We just don't have the capacity for that. The distinction I want to make sure you're aware of and comfortable with is if it's substantive, like if you're changing something about your articles of incorporation or organization that is one of those fundamental elements that are specified in the formation. I'm not talking about your email address, but like what are the number of directors or something like that. Let's just take that as an example. Then that requires an amendment and we review that. We make sure that the person submitting it has capacity and they've signed it appropriately. They pay the right fee. So that goes through that review process. This is more like, we just want to make sure you can easily update your contact information. So, and then the third leg of that stool is, we already talked about the statement of change, which also gets reviewed in-house. That is the way we propose you change agent information. It's critical that we know a valid agent, that you've attested to their acceptances of the position, that you have a valid Vermont address that you're using for your service of process contact. Feel good about all that? So I think that sort of covers the field for the green. I mean, it's the same here with LPs. It would be the same for LLCs. Yeah. Everybody get a good feeling about the green, harmonizing the email addresses.
Do you want the truth?
I'm
I'm not gonna lie, I'm sorry, I'm not really good with this.
No, I welcome it. What?
But there's nothing that you could do to change it. It's a lot of stuff.
Yes. It is a lot of stuff. It is a lot of stuff.
And you mentioned how really interesting, like goes into a civil court in Washington County. That are these changes in any way, will they simplify things for the courts in their case law, or is this just a new? It'll be no big deal. No, it would not cause any challenges.
Sure.
I'm just curious how those two systems might work together.
Right. It's a fair question. We will get to the administrative authority, and my answer to you is my hope is that some of that in the theoretical world could alleviate a burden on the court if they could come to us first to resolve very narrow issues. How many court cases are there on disputes about the use of a assumed business name? Probably zero. I mean, it's not a lot.
Okay.
It's not a lot. But that said, it's better so the burden on the court, probably not going to notice, but responsiveness to the people, I think way better. For two reasons. First, law enforcement doesn't have the capacity to enforce the stuff that we're going to talk about in the administrative authority area. Like right now, if somebody's using your home address for their business and you didn't give them permission to do that, I mean, technically that's a crime. And law enforcement is supposed to review it and then bring an enforcement action in civil court or in criminal court. And like, it's just not going to happen. And we have a workaround, but it's not clean. And so, and this happens and since I've been here, this has happened, I don't know, 10 or 12 times. We get a complaint like that. And the same with these synthetic identities I was talking about the last time I was here. One of the things we're proposing is in those cases we think of fraud or misuse of information or false information, we'll give you due process because that's required by the Constitution. We'll observe the Administrative Procedures Act, but we want to be able to respond to that administratively rather than the AG or the state's attorney and the courts having to be the people that would respond to that. So this stuff about address information, small potatoes, not going to really come up ever for courts or law enforcement or anybody else. But the stuff about potential fraud and resolution of, sketchy records or false fraudulent activity, that definitely could have a positive impact. That will have a positive impact.
I'll just say from my experience dealing with some of these sort of local nonprofits, things like that, you organize around a particular issue and have some sort of general familiarity with business law, but not a whole lot. And one of the things I noticed when I was trying to help the local organization out is that a lot of the terms in each of these different chapters dealing with a specific type of organization, a lot of the terms are kind of different. So just from my perspective, just, having some common terms around what do you mean about, filing your original documents, reporting on a regular basis, just harmonizing the terms would be helpful to, I think, a lot of organizations.
I had exactly that experience yesterday. I was on our own website. I pulled up the tile card. I saw certificate of change of business. And I'm like, what the hell does that mean? Like, I had to think back through the sessions, like, which one does this apply to? And at the end of the day, I'm just like, oh, that just means an amendment,
Correct.
you know? And on the other side of this, if this passes, you know, we can clean that up a little bit and just say, when you come to our site, we're all talking about the same thing. We're talking about a business amendment. No matter what kind of entity it is. You told us this one thing, you need to change it, amend it, be done. And the vagaries of the different terms and all across the statutes are the product of years of different organizations adopting model laws. And then there is a golden standard, Uniform Business Organizations Code, that would bring everything into this one beautiful package. And that's a dream we can all aspire to. But so far, that's been more 500 pages more work than anybody has wanted to do.
I think at some point in 2018, maybe, talking about doing a hub and spoke model type where all corporations have and business entities have things in common. And from there you go out to different organizational groups. That never materialized.
Well, mindful of the time, we have 19 minutes. If you would like to look at the harmonization of name provisions, we could knock that one off in relative ease. This one is a slightly narrower scope, but so dark yellow or gold, these reflect changes to certain aspects of the name requirements governing registered business entities. So there's 3 buckets here, okay? The first is a reserved name. And you'll, I have my bullets. Currently, the majority, though not all, of the governing statutory provisions for various entities authorize a person to reserve a name for 120 days, right? Seems pretty straightforward. Problem here, as with a lot of these, is that Representative Olson observes, they're not all consistent across the types. Even though they're all called name reservation, they have different standards. Some allow for renewal of the reserved name, some do not. Some allow renewals, but only 2. Some provide a renewal window during which you would renew your reservation of the name. Others don't say when it happens. So basically what the recommendation here is that we just use one standard reservation of name provision for all. And that's kind of what we're doing right now. Anyway, we made this decision in the course of our work building the system. We observed that the language in section 1652 technically applies to any reservation. So we just decided, for purposes of building a system, rather than having 8 contingent models, depending on what kind of entity you're going to file the name for, we just said, let's just run it all through 1652. So this essentially would codify what we are doing in practice, what is already allowed in law, but causes confusion to people because they'll come to us and they'll be like, wait a minute, I want to renew it because it's an LLC. Actually, the renewal is not available there. So anyway, you mentioned the one harmonized provision to rule them all. That was the UBOC. That's actually the basis of this. So it's the same standard that's in there. So if I can pull it up, you'll see what we're going with. Here it is. Put it in a new place. All right. So there's this new sub 3 that's. Sorry, did you have a question?
Yeah, just to clarify.
Sure.
So has Vermont adopted the Universal Business Organizations Code okay, but is it generally seen as best practice in the industry?
I don't know how to answer that. What I would say is if I were starting from scratch, that's the way I would do it. And I think it's hard for me to impute a position to 50 plus US jurisdictions. They probably would too.
Okay.
But that said, that thing's been around now for almost 2 decades and like one jurisdiction has adopted it.
Yeah, I noticed it was only like
Yeah.
Idaho.
And the reason is you have to upend everything. Everything. You have to repeal all your existing business organization statutes and replace them with this UBOC. And people don't have the appetite for that. And even last year when I dared to suggest that we consider it, people were frankly like, why in the world would we do that? Because it's just a lot of change for, perfection, enemy of the good, blah, 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 type thing. You could get, and frankly, like what we're proposing in this bill gets us maybe a big step closer. All these harmonization efforts are to try to standardize what can be standardized. Because even if you adopt that, you still have to have separate law governing each entity type. Otherwise, there wouldn't be separate entities, right? So all the bits about the LLC Act, for instance, that say like members' contributions and rights of distribution and dissociation, like all that stuff is unique to LLCs. That's why an LLC is an LLC. So we're trying to say this piece that has to do with just the administration on the state side, we can make that as streamlined as possible. And then we can still have our substantive statutes that govern the inside baseball for each entity type. We're not full-blown UBOC here by any stretch, but we're trying. We're taking steps. It's a great question. So 1652 would be the standard for a reserved name. So you would be able to reserve the exclusive use of a name by delivering the application to the Secretary of State's office. The application would state the name and address of the applicant and the name to be reserved. If the secretary finds the name is available, you can reserve it for 120 days. It does offer the opportunity to transfer the reservation to another person just by filing a notice of transfer. This is silent on renewals or anything else. So what that means to us is after 120 days, you want to renew the name again, go ahead, just file another reservation. And it's sort of fair game so that, one person can't just keep a name out of circulation forever. We're not looking to thwart competition. We're trying to have an even playing field. You're not ready to form the business yet, but within the next 120 days, you probably will be. Reserve the name, and then when you're ready, come file. And our system says, do you have a name reservation? If it does, it puts you into a flow that uses that name. So that would be the standard.
So would 1652 together with 1653 cover all the organizations you do this, you deal with?
52 would be everybody, anything from an assumed name all the way through all the entities. 53, and we're ready to go there, is the assumed business name of a business organization. So remember that 1621 assumed name partnership UNA.
Okay, I get it.
That's all individuals.
Yeah, okay, I see.
The reason that 1653 is now simplified for a business's assumed name is because we've already got all the information for the business that's registered with our state. You have to be authorized to do business here to conduct business under assumed name, which means you've already come to us. We know who you are. You're domestic or foreign. You've got your authorization. Now you can add an assumed name to your record if you're a business. We don't need all the stuff from 1621 because we've got a record for you already. Excellent. And then what was the third piece for the name is a registered name. And so don't be confused. We've got reserved name, which is I want to hold the name for 120 days, see what happens. We've got the assumed name. We've already talked about that's your sole proprietor doing business under some trade name, or a business decides to adopt another trade name. That's 2. 3 is registered name. And this is a much narrower subset. This is just foreign corporations who are not doing business here, but want to hold their name in Vermont. So that's before, maybe you got a Massachusetts corporation. You think you're gonna come to Vermont at some point to do business, but you're not ready to register here for some reason. Then you're able to come to us, register your foreign name, and hold that in for a year. And those are renewable. So that's sort of like preserve the rights, safeguard my intellectual property from another jurisdiction until it's time for me to come to Vermont. And the only change that's really happening here is to make it clear that, and you'll see it in this bullet, the current statute sort of misleading. It requires a foreign corporation to adopt a trade name if its actual name is non-compliant. And the use of the term trade name suggests it has to go through the assumed name process. So we're just switching this. Instead of saying trade name, we want to use the term alternate name. That's reviewed in-house. That's either they have to add the corporate signifier to comply with our law, or the name's not available and they're going to adopt an alternate name for use in this state. In either case, we want to just be clear that this is an alternate name, not a trade name. They don't have to do the 5-year registration and adopt an assumed name per se. This is the registration. This allows them to adopt an alternate standard. Is that clear? Ish. No, it's a lot. I know it's a lot. How's everybody feel about names? You feel good about names? Questions?
Does that have, on the most recent points, there's not a time, that's not a reservation for 120 days. Like that's a registered name where they are like ready to go. The intent is to do business. And then it's just a matter of understanding whether that's available or not. Compliant.
I would say it a little differently, because this is for an entity that already exists in some other jurisdiction, a corporation or a nonprofit, and it's organized in Maine, let's say, and they're not doing business in Vermont, and we don't know if they will, but they want to safeguard their name in this state. And so it's a 1-year.
On a year-to-year basis.
Yeah,
Okay.
and it's a registration of that name. Doesn't authorize them to do business here either. It's just a way for them to preserve the record of the name in this state.
And the distinction between a reserved name is that they already are a business entity somewhere. And you don't want to have them go through a 120-day renewal process.
Well, it's broader than that. So the reservation could be anybody. It could be you are going to be a sole proprietor and you want to maybe start doing another line of work, and you're going to do, handyman's tree service. And you're not quite ready to start doing that yet. You just want to reserve the name. So the reservation is sort of before you start that activity. You know what I mean? Reserve is in anticipation of activity. Register is I'm doing activity in another jurisdiction and I'm registering with Vermont to safeguard the name. I already exists, but somewhere else. So reserve sort of upfront.
Yeah.
Assumed is kind of while you're doing business here under another name, and registration is extra jurisdictional. So that's sort of the spectrum.
Would a foreign business then have to go through the name reservation process if they do decide to actually become a active business in Vermont?
Are you talking about if it's registered, it has a registered
Yeah,
name?
like they're already registered, they're domiciled somewhere else, they
Yeah.
want to do business here, do they
Sure.
need to also go through the reserved name process?
No, they don't, but they will need to actually, file the application for authority to do business here.
Okay.
So that you could be registered but not allowed to do business yet. And you have to come and file and get approval. You have to give us your certificate of good standing from your home jurisdiction, tell us you're okay there, and then you're authorized to do business in Vermont. Right. Yeah. Did you have a question?
I just, Jonathan answered a lot of it, but I just want to clarify.
Yep.
A foreign corporation is one that does not exist in the state. So like a corporation that is in Maine, for example, would
Mhm.
still be considered a foreign corporation.
Yeah, it exists. It's domiciled somewhere other than Vermont. That's what
Okay.
makes it foreign.
Okay,
So whether it's Rhode Island or Germany, it's a foreign.
that was it.
Yeah. And it exists by virtue of that jurisdiction breathing life into the entity. It can do business in Vermont, but it has to file the paperwork with us. If it's not ready to, it could register the name. It could reserve a name. Yeah. That's what makes it foreign. It's organized under another law. Right. We're out of time. Sad. This is so fun.
What do we have left, David?
Well, we have to do the administrative procedure and authority, which is, a big one. We have to do the fees.
Don't go too far in the fees because that's
Sure.
gonna be done upstairs.
Yeah. Service of process provisions that's a 3-minute conversation. And then the study. So I would say, depending on how many commas you want to examine, we probably have like 30 minutes at this high level, and then you get it gnarly as you want with words.
Trying to see if we can get this moved by.
I'm here for 10 to noon.
Oh, that would be, I think plenty of time for my purposes, at least.
All right, everybody, we are on the floor at 10. When we caucuses, we are back here at 1. To
UCC.
Yeah, the UCC bill. I was gonna try to get the number, but I don't have it.
That's even more fun.
It's even more fun.
Fun just never ends.
So, energy